Hopefully you can hear me. My name is James Rodriguez. I am the current president of the Clallam County Bar Association and also have the privilege of serving on the board of the Clallam-Jefferson County Pro Bono Attorneys, and would like to welcome you to this presentation entitled Navigating Eviction in 2022. We have a number of panelists to present a lot of information for you today, so we'll get started very shortly. Just wanted to give some initial instructions to all those in attendance to help with what we're about to do. This is open to the public, so those of you who are here to learn more about evictions, welcome. There are also a number of attorneys present, and for attorneys, if you've pre-registered, we already have your bar information and can report it for CLE purposes. If you have not pre-registered, please place your name and bar number in the chat so that we can capture that information and submit it for CLE credit. Typically, we ask attorneys to donate for the CLE credit, and I believe our typical request is $35. But of course, anybody in attendance is welcome to donate, and I'm going to place a link right now into the chat to facilitate those donations. So please visit that link if you would like to donate to the Clallam-Jefferson County Pro Bono lawyers. Questions will be taken throughout the presentations, but we will try to save some in-depth questions for later, perhaps after the panelists speak. Quick questions may be handled within the presentations, but apologies if we don't get to your questions as timely as you would like. There's a lot of information to present. So in that regard, I'll tell you the panelists are present. The first two that you will see are Noah Harrison, who is an attorney in private practice in Jefferson County primarily, but occasionally appears here in Clallam County as well. Ted Howard is an attorney with the Clallam-Jefferson County Pro Bono lawyers. Noah will be speaking primarily from the perspective of landlords, and I believe Ted primarily from the perspective of tenants. Following them, we will have Michelle Lucas, who is the managing attorney with the Northwest Justice Project, Renee Riopelle, who is the executive director of the Peninsula Dispute Resolution Center, and Cherish Cronmiller, who is the executive director of the Olympic Community Action Programs, or OlyCAP. We also have with us the Honorable Judge Simon Barnhart, who is the judge of the Superior Court in Clallam County. And he'll be perhaps interjecting from here a little bit on the presentations that are made, but we'll likely expect to hear more from him at the end. So given those introductions, no further time needs to be spent, I think, on introducing our first two panelists again. Noah Harrison and Ted Howard, please proceed.
Will do. Thank you for the introduction, and thank you everyone for joining us. I'll just, Shauna, I'm disabled from screen sharing. Can I get a change there so I can share these slides? Anyway, while I'm waiting for that, so I'll be giving a general overview of the big changes in landlord-tenant law since last year. And our last CLE on this topic back in September, Steve Robbins from NJP covered some of this. So if you were able to attend that, apologies if this is duplicative, but hopefully it'll be a good refresher in any case. So a big change why is it like this? A big change since September is that the eviction moratorium and the bridge to the eviction moratorium has finally ended. But there are a few things that are kind of left over from that. And the main one is that reasonable repayment plans are still required for unpaid rent that accrued between the beginning of the moratorium back in March 1st, 2020. I guess that's the beginning of the public health emergency, and 6 months following the expiration of the public health emergency. And that's still in effect as of now. I believe it will continue at least through July 15th, possibly longer. So this is in effect at least through the end of this year. A repayment plan can't exceed 1/3 of the monthly rent. So that's a tenant would be paying their regular monthly rent and then 1/3 of that to pay back rent that's owed in the past. And offering this repayment plan is a prerequisite to moving forward towards an eviction. And they have to allow for any source of income, and that includes rental assistance payments. I have seen some landlords who haven't wanted to accept rental assistance payments for tenants who owed back rent, but as part of a repayment plan, they have to. And that's codified at 5918-630. This is only really in effect until mid-June, so I don't think it's going to be relevant to anyone. Just going to skip it. So with the bridge gone, what protections are gone? Well, landlords can now serve notices based on past rent due. They can treat unpaid rent as an enforceable debt if it accrued after July 2021. They can charge late fees again, which they couldn't under the eviction moratorium. And they can once again increase rent, and many certainly have started to do that. So the long-term changes in the law that took effect in May 2021, those were passed in House Bill 1236 and Senate Bill 5160. They amended a number of sections of the law and created some new ones. So I'll start with the ones that were in 5160. At 5918-057, there's a new mandatory form for 14-day non-payment of rent notices. Most importantly, it needs to include language about the legal help that tenants can get, particularly from Northwest Justice Project, their number, and WashingtonLawHelp.org, which is a great resource. 5918-365, similarly, the summons that comes with a complaint must have some of that similar information, right to counsel, and information about dispute resolution services. And those summons requirements and other procedural requirements for unlawful detainers or evictions also apply for mobile homes. This is a smaller thing, but there's a small slight change, the landlord mitigation program. I don't know too much about how much funding is left for the landlord mitigation program. But a lot of tenants who owe back rent for the period of the eviction moratorium, they may still not be able to pay that. So for landlords who do have, who have rent owed to them, this is an option to seek reimbursement from that fund in lieu of suing a tenant for damages or moving towards eviction. So that may be a good option for a lot of landlords whose tenants can't pay them back. 5918-320 just adds a few extra things that a landlord can't put in an agreement, certain rights that can't be waived by the tenant. And 5918-625 says that a landlord can't report to a prospective landlord any non-payment of rent from the beginning of the public health emergency to the end of last year. And they can't report any unlawful detainer that resulted from non-payment of rent. And the prospective landlord can't take any action based on that non-payment of rent. They also can't take any action based on a history of COVID-19 infection or exposure. And more broadly, prospective landlords can now not inquire about, consider, or require disclosure of medical records or history unless that's necessary to evaluate a reasonable accommodation for disability. I don't know that I've ever heard of a landlord asking for medical records. I don't know if it's at all common, but it's something that they're now broadly prohibited from, not just related to COVID. And there's potentially a penalty of 2.5 times the monthly rent for doing so. 5918-640 is where the right to counsel program is codified. And I'll let Michelle talk about that more. 5918-660 establishes the eviction resolution pilot program. And I'll have another one of our panelists, Renee, talk about that. So moving on to House Bill 1236, makes a few small amendments to sections of the RLTA, but most importantly, that's where the just cause eviction provision is. And that affects month-to-month tenancies most of all. And I think in an area like this, where we have less multifamily housing, more single-family housing operated by smaller landlords in more informal situations, I think we have a relatively high proportion of month-to-month tenancies. So the just cause eviction is, I think, even more important around here. Before we get to just cause, 5918-230 just changes the liability for landlords using prohibited provisions in rental agreements slightly. The standard used to be whether the landlord was using the provision deliberately. Now it's whether they're doing it knowingly, and the damages are increased a bit from actual damages plus $500 to actual damages plus 2 times the monthly rent. So with just cause eviction, there are still scenarios where a landlord can end or decline to renew a tenancy without needing any other cause. Those are basically when there's a fixed term tenancy, 6 or 12 months, and with a 60-day advance written notice, the landlord just says, sorry, the tenancy won't be continued after this, and they don't need another cause. But if the landlord is trying to end a tenancy before the end of the term, or it's a month-to-month tenancy, then they can only end the tenancy based on one of the causes that's listed in this law. So let's go through the causes. The biggest one is non-payment of rent, and there are additional procedural requirements that we'll talk about more later. There's a substantial breach of a material program requirement or a material term of the lease, a tenant obligation imposed by law, and that's a 10-day comply or vacate notice. And the tenant has to be given an opportunity to comply and fix their breach within the 10 days. There is, I think, sort of an outstanding question about what exactly constitutes a substantial breach. And I think we'll learn that over time through what the courts tell us. When a tenant commits or permits waste or nuisance or engages in unlawful activity that affects the use and enjoyment, a landlord only needs to give a 3-day notice and not a chance to conform. Waste and nuisance has a sort of technical legal definition. So this isn't exactly everything that would colloquially account as a waste or a nuisance. This is something that really completely interferes with quiet enjoyment of the premises or a neighbor's premises. If an owner wants to occupy the unit or an immediate family member wants to occupy and there's no equivalent unit in the same building, owner just needs to give a 90-day notice. And there's a rebuttable presumption here that they're doing it in bad faith if no immediate family member actually does live there for at least 60 days in the 90-day period after the tenant vacates. So theoretically, a tenant could sue to take back occupancy of the unit if an owner doesn't actually move in or an immediate family member doesn't. It's also a 90-day notice if an owner elects to sell, and there's again a rebuttable presumption it was in bad faith if they don't actually put the house on the market, or they withdraw it, or they end up renting the unit to another tenant. In a situation where the tenant is basically a housemate or roommate of the landlord, they share the dwelling unit or access to a common kitchen and bathroom area, then the landlord only needs to give a 20-day notice. It's basically like month-to-month tenancies were before the change in the law. 20-day notice, don't need to give another reason, just you don't want that roommate anymore, that's fine. For conversion to condos or a non-residential use, that's a 120-day notice. I don't know that we're going to see a lot of that around here. If the premises have been condemned, that's a 30-day notice. Also a 30-day notice for the end of a transitional housing program or a similar program. I don't know that there's a lot of that here, but I know there's some. Slightly similar to ending a fixed term tenancy with 60-day notice. If a landlord offered a new agreement 30 days before the end of the term of a fixed term tenancy, and the tenant just declines to sign the new agreement, the landlord can end the tenancy without additional notice, but any new terms in the lease have to be reasonable. If the tenant made intentional, knowing, and material misrepresentations or omissions on their application, and those misrepresentations actually, in their absence, the landlord would have requested more information or declined the application, landlord can end the tenancy with a 30-day notice. And another one that I think will become maybe a bit of a point of contestation, 60-day notice for any other good cause not listed that constitutes a legitimate economic or business reason. As this is a new law, I don't think there's been much case law interpreting what constitutes a legitimate economic or business reason, or how much documentation a landlord needs to provide to prove that this other reason exists. So I think we'll find that out over time. If a tenant needed to register as a sex offender and didn't, 60-day notice. If a tenant made unwanted sexual advances or sexual harassment at an owner, property manager, employee, or another tenant, that's a 20-day notice. As with the conversion to condos, it's a 120-day notice if an owner plans to demolish or substantially rehabilitate. That this could be another point of contention, the meaning of substantially rehabilitate. The law defines it as an extensive structural repair that requires a permit and results in the displacement of an existing tenant. So the landlord here is displacing the tenant based on substantial rehabilitation. Well, what does substantial rehabilitation mean? It's when a tenant is displaced. So there's a little bit of circularity here, and the courts may give us some more clarification eventually. And finally, there's what's sort of a 4 strikes rule. If a tenant has been issued 4 10-day notices in the last 12 months, then a landlord can issue a 60-day written notice ending that tenant's tenancy. And that's even if the tenant cured their breach for each of those 4 notices. But one important thing to note is that not only does the 60-day notice have to include attached all 4 of the 10-day notices that sort of constitute it, each of those 10-day notices need to have language sort of warning the tenant that this 4 notice, 4 strikes and you're out, can happen. And I haven't seen any landlords yet issue 10-day notices that include that language. So as it stands, a landlord couldn't just collect up old 10-day notices, sort of add them up and say 60 days and you're out. So both the right to counsel and the ERPP are sort of put into practice in both Jefferson and Clallam counties with standing orders in the Superior Courts. They're pretty much identical, so I'll just let Judge Barnhart maybe talk about this more in his section and move on to our next speaker. Thank you very much.
Okay. Hello, everyone. My name is Noah Harrison. I'm doing a lot of landlord-tenant eviction these days in Jefferson and Clallam. Sean is going to call up my slideshow here. It's probably the worst PowerPoint presentation in the history of CLEs. So there's probably some people out there that are landlords, some attorneys may be thinking about getting into this. I would tell you it is a difficult legislative climate these days if you want to be a landlord. Next slide, please. From the trenches, just by anecdotal evidence and some of the things that I've got going on, you wouldn't believe the stories. One of them on the slideshow, a tenant from the local news, he blew up the shed, he blew his arm off, and when we tried to evict on a 3-day notice, the court said that was a fact issue, and no matter the police reports, no matter the ATF presence, essentially the court denied to evict on a writ of restitution. I have a case over in Kitsap where a guy found out his neighbor said there are people living in your house, and he went there, and turns out he had a bunch of squatters there. And the current climate with law enforcement, they said it's a civil matter. You're going to have to evict them even though they had no rental agreement. So that kind of falls out of this. That's more of an ejectment action. I have a case where a son is slowly stripping the kitchen sink literally from the house And the only way that he doesn't live there anymore, but the only way we can get the sheriffs to enforce it is through a writ of restitution and a essentially no contact or no trespass. They go on and on and on of no matter how bad you think your story is, there's a lot of them out there that are worse. Next slide, please. Okay, so my perspective is from the landlord. So you've rented to somebody and for whatever reason you want them out. So as Ted said, we are in a just cause environment with the law these days. So you have to familiarize yourself with what law applies here that I might be able to evict this person. There are 16 reasons, and for just cause, one that Ted went over that you don't need to cause. So for those landlords out there, you start with a 6 to 12 month periodic or finite lease, essentially 6 to 12 months. And then if you have one time option opt out if you give them 60 days notice. With all service notices that we're going to come on to, it's from the start of the rental period. So if you serve somebody on the first of the month, you will have basically wasted 30 days because you need to get them, you need to serve them before the start of the rental period. So you always want to serve, the 30th, the 31st, you want to serve basically closest to that event that you can without having to waste essentially, if it's a 60-day notice to conform in some respects, if you serve it on the first, you will have wasted all that month because you didn't do it before the first of the month or the start of the rental period. So you're going to go through those, familiarize yourselves with which ones. Next slide, please. And then you have to understand, what do you need to do next? So understanding the requirements for your notice. For instance, anytime you have a notice to comply, basically they're breaking the law or a rule of your lease, you have to understand what's involved with complying with the law, essentially, because we're in a strict compliance state. Essentially, the tie goes to the tenant, and if the landlord failed to put in something that was statutorily required, that could be essentially found not to have complied, and the judge may not grant the writ, or Ted and his colleagues will happily point out to the judge that the notice failed and there's essentially can't go forward. Finding counsel is very helpful. We have a question: can you force a month-to-month tenant to sign a 6 or 12-month fixed-term lease? No, you can't necessarily force them. You can offer it, and if they won't sign it, essentially, I'm uncertain on how enforceable that would be. Essentially, you're asking them to sign a fixed lease, and they're declining to do that after their term has expired. I believe that would fall under the 5918-650. If you've offered a lease and they've declined to sign it, maybe that might be grounds to go forward. It's really difficult, if you're listening, from Clallam and Jefferson to find an attorney for landlord tenant. I'm one of two that I know, and there might be some practicing here and there, but finding legal counsel can be very difficult. Start saving your nickels and dimes, meaning, an average cost for an eviction is around $1,500 to $2,000 if it goes all the way through. It can be more than that if it has to go to trial, or if there's opposing counsel on the other side, that can add up quickly. You also have to pay for filing fees, service fees to whoever's doing your process serving, the court fees for basically stamps on the writ of restitution from the clerk, as well as the other thing to consider is negotiation costs. And I say that with the idea that not everything has to end up in court. So I've had many a landlord that has chosen to offer negotiation sum to the tenant, because at the end of the day, as much as it hurts to pay them to leave, sometimes that's the most expedient and cheapest way to go forward. So that's one of the costs associated with evictions. Next slide, please. So what can you expect from your attorney? Essentially, the first thing is to identify the eviction path. What do we have here? Okay, so you want your tenant out. Is it because they haven't paid rent? Is it because they've essentially violated a term of your lease? Once you identify the path that's possible going forward, then the attorney would need to create the notices, essentially for service. Service can be accomplished a couple of different ways. One is you have to post in a conspicuous location for your notices. Generally, that means the front door. And then you have to place in first-class mail to that address. It doesn't have to be certified, doesn't have to be return receipt or anything like that, but first-class mail. The other way is personal service by handing to the client, or excuse me, the tenant, the notices. So the attorney can help you with that. Then they have to prepare the eviction documents. So there's always a time period between the notice of the event, whether it's 14 days to pay or 10 days to conform or 3 days to quit. After that time period is gone, then the attorney would consult with the client and prepare the eviction documents for filing. And there's 6 or 7 different pleadings that need to happen every single time from there. Then the possibility for negotiation. So maybe either before you file or after you file, connecting with either opposing counsel if they have one, or the tenant themselves to find out if they are open to certain resolutions that might involve them leaving voluntarily. Then after you file, you've got your show cause orders, which is essentially the shortcut to getting what's called a writ of restitution, which is the ability to apply to the judge to have that person essentially escorted off the property by the sheriff's department. And the writ can be the end of the case, or there's a possibility that there is a factual issue that would result in the need for a trial. I'm not aware of any trials in Jefferson or Clallam that have resulted from an eviction. And interestingly enough, the law says it is a jury trial, but that can be waived and make it a bench trial. So I have yet to see one, but it's certainly possible. Lastly is finalizing the eviction with the writ and or trial, basically following up with the client to make sure that everything went smoothly, that they are coordinating with the sheriff's department to make sure that in the event the writ is necessary to be executed, meaning the sheriffs actually go to the house or the residence, and their job is to remove the person who is still there. And it's the landlord's job to then either store the property and change the locks or remove the property to the nearest public right of way, essentially coordinate that role and help the landlord get through that process of making sure they're following the law. Next slide, please. Okay, so the tenant, as you've heard, and you will hear more of, is entitled to an attorney if they cannot afford one. Essentially, that's not always going to be the case as far as Northwest Justice Project goes, meaning they could have their own private attorney. I've represented tenants who are being evicted as well. So essentially, you have to identify the eviction issue. What is it they're being accused of doing? Is that issue a contested matter? Meaning, is it alleged that they violated the lease by not changing out the batteries in the smoke detector? And they got a notice for that. And what are the mitigating factors, or what is your client's story versus the other one? Review the notice requirement. So essentially, what did they do to get notice? What did the landlord comply with the statutory requirements on how much notice they were given? Then the possibility to negotiate with the landlord, find out what do they want? Is it that they just want their money because it's a notice to pay or vacate? Is it that they want the tenant gone no matter what? Or is it they want them to turn the music down and just be a good tenant? So basically reaching out to the other side is always appropriate, even if you're rebuffed. Delay. The longer the client stays in the house generally, or the apartment, it's better for them, because usually in this tight rental market, it can be very difficult. So whatever tactic you can employ, whether it's taking advantage of the court delay by court rule, essentially, that allows a 1 week continuance on a show cause order, or an agreement of a delay to try to work further settlement negotiations out. Is my client judgment proof? At the end of the day, If the landlord prevails, they can be entitled to statutory attorney fees and costs. But if your client has no money, no job, certainly that can factor into how you negotiate or what factors, because inevitably the landlord is going to be paying probably significant amount of money to evict. And if there's a path forward that they don't have to pay that kind of money, that can be leverage. And then, of course, you're reviewing the pleadings and the contested facts, because at the end of the day, if your client is saying, no, I didn't break the lease, I didn't do a rule that, or the law, I didn't do it, then essentially you go before the court and you tell them, no, judge, don't sign that writ of restitution. We want a trial on this matter because the landlord's not going to be able to prove that my client didn't do whatever they're accused of doing, essentially. Next slide. Okay, so you go to court, and what is the court going to be looking at? And Judge Barnhart certainly can educate us, and I think will step in. Certainly, I invite him to if I say something that he doesn't agree with. But they're looking for statutory compliance, first and foremost. This is, again, as I said before, it's a strict compliance kind of situation. So they want to make sure that process of service was appropriate, that there's jurisdiction, that the issues essentially are before the court properly. It's always advisable when you're the attorney filing these, you want to give the court more, you're almost litigating it ahead of time. You're giving them all of the documents necessary for them to get the complete picture of what's going on. For instance, obviously, there may not always be a lease, but if there's a lease, you want to include that. All of the notices or pictures of the non-conforming conduct, you want to include that. You want to include all of your proof of service. How essentially was this, was the tenant notified? There was something posted on their door? Was it personally served? All of those, you want to include them in your initial filing so the court can see everything here has been documented. Is the issue contested and is it substantial? So essentially, the court is going to be looking at, okay, it's a non-payment of rent. Can they prove that they paid the rent? Is there some issue that essentially the court says this is not straightforward, and I have some questions about whether they actually failed to abide by the terms of their lease. And again, the tie goes to the tenant for now. The legislature and the case law represents the power of the landlords, and the case law generally reflected that any abnormalities, anything that was unclear would essentially allow the tenant to continue to reside there and would reject a landlord's attempt at an eviction. I'm hoping from the landlord's perspective, that pendulum is going to slowly swing a little bit now that we have laws that protect tenants quite a bit more, and they're often going to be represented as they weren't in the past. Next slide. Ted went over these, but I'm just going to briefly, the ones that are, I find are used the most, 10-day notices to comply. Obviously, anytime they're breaking a rule of your lease, you want to document that. You want to serve that notice. 14-day pay or vacate, 3-day notice to quit, and then the terminate for sale or occupation. All of those are the most common. Certainly, there are others out there, but those are the ones you're going to find most common. Next slide, please. Okay, so it's not business as usual for landlords anymore. The time to rent when you just have one person saying, hey, this is a buddy of mine, I think it'd be appropriate for you to rent to him. If you're a landlord and you're doing that, then quite frankly, if you find yourself with a bad tenant, maybe that's the cost of doing business for you. But it is now about screening your tenants proactively, making sure you have a lot of letters of recommendation, doing a civil litigation check, doing a criminal background check. I would want 2 or 3 references from old landlords, if possible. There is no more Mr. Nice Guy. So if you're having a problem with the tenant and you're trying to work it out verbally, okay, that's good. But at some point, You need to start documenting. At some point, you need to start giving notices, because their job is to stay as long as they can. Your job is to do what you have to do in case you need to go to court to get them out. So prepare like you're going to litigate, document everything, take pictures of the notices you put on their door, take pictures, screenshots of your communications in text, but do what you got to do, because it's again, a hostile legislative climate right now if you want to evict. Next slide. All right, so these are my perspectives and my opinions. They don't represent whatever legislator was thinking, but the pendulum has swung way to the left. So I think it was a reaction to the homeless crisis and a lot of different factors. But if you're a landlord these days, it is, you might be questioning. In fact, all of my landlords question why they're in the business anymore when it's their property, and it's really, really difficult to get people out. You can call your legislatures, give them anecdotal evidence. You can write them emails about what it means to mom and pop when they're being financially or mentally abused by their tenants, and the just cause situations don't apply. In my opinion, in the end of the day, this is going to mean less housing and less rentals for people, as the landlords won't do it, or anybody that was marginal. Anybody that said, I can take a chance on this person because I can always evict them later with a 20-day notice. Nowadays, somebody would be ill-advised to rent to somebody who might have a history that would lead to problems in the future. Thank you, and I'll be available for questions.
Thank you, Ted and Noah. We do have a quick question from the chat, and the question comes from Jeff Davis, and the question might be best directed to Mr. Harrison. Can you force a month-to-month tenant to sign a 6 or 12-month fixed-term lease?
So I briefly tried to address that when it came up, and I don't know, Ted probably has an opinion coming from the tenant side, but I think that is a term of a new lease, and the just cause says, look, if they won't sign that, you're offering that to them and they're not going to sign it, then you can evict possibly. But it's a good question. I'm not sure the answer. What do you think, Ted?
From my reading of the law, that would not be, you couldn't do that in a month-to-month tenancy. It would only be if it was a 6-month or 12-month situation. But.
Yeah, I agree with him, actually. So yeah, the idea is, or the answer is collectively no. And one of the things that hopefully Ted and myself conveyed to you all listening is the law's new. We're all learning how the judges interpret these, and until case law comes out, until appellate courts have weighed in, until we have some anecdotal evidence on different cases, we're all learning as we go for how to apply these different facts to the judges and see how they are handling it.
Okay, and what appears to be another quick question from Sam Wilson, would that apply to 59.20 manufactured home communities as well?
Would what apply to having them have to sign trying to get them to sign a term?
That's my understanding. Yeah.
I don't know.
Yeah, generally month-to-month tenancies are, the policies against them for mobile home tenancies. A landlord is required to offer a year lease. And if they never offered it, it's defaults to a year lease. They can agree to have a month-to-month tenancy, but you have to offer it. And there's really no reason to want a month-to-month tenancy when you own the home and it's so expensive to move it. So generally, I wouldn't think that would come up much, but I think the answer would still be no.
Okay. Well, thank you, Mr. Harrison, Mr. Howard, for your presentations. We're going to move on to another set of speakers now, but between now and then, I'd like to remind anybody who may have shown up late, if you're an attorney and you did not pre-register, please give us your name and bar number in the chat so we can make sure that you get credit for CLE. I'm going to resend the link for donations to the Clallam-Jefferson County pro bono lawyers. Again, the suggested donation is $35 for attorneys with a CLE, and anyone else who wants to contribute is more than welcome to, of course. And if you have questions, feel free to drop them into the Q&A section, which should be a button on your screen, or in the chat section. So now I'd like to introduce another set of speakers who sort of represent the excellent community resources that we have in Clallam and Jefferson counties. for tenants to rely on. One is Michelle Lucas. Michelle is the managing attorney of the Northwest Justice Project. We also have Renee Riopelle. She is the executive director of the Peninsula Dispute Resolution Center. And we also have Cherish Cronmiller, who is the executive director of the Olympic Community Action Programs. So if you take it away.
Thank you so much, James. Hi, everyone. Thank you for having me. My name is Michelle Lucas. I am with the Northwest Justice Project's Eviction Prevention Unit. So I am a managing attorney with Northwest Justice Project, but of only a small portion of a much larger organization. So I'm going to go ahead and share my screen. Let me know if everybody can see that. Is that coming up okay?
Not
No, I
yet.
don't see it yet.
You can't, or you, oh, it's because I didn't hit the button. That's why. Don't worry about it. There we go.
Looks good.
Perfect. Thank you. Sorry about that. So this is just the cover page. So I'm going to be discussing what the right to counsel program in evictions looks like in Clallam and Jefferson counties. And Shauna will distribute these slides afterwards, is my understanding. So let's see. Okay, so just as a quick introduction to the Northwest Justice Project, Northwest Justice Project is a statewide civil legal aid organization that provides legal assistance for all sorts of civil legal aid issues for low-income folks in the community. This is just kind of a brief synopsis of the work that we do around the state, and a map that kind of shows where our offices are located. So our main office in this area is located in Port Angeles. And one program that's not mentioned on the previous page that I want to make sure I reference is what we call the Clear Line. So Northwest Justice Project does provide full representation in all sorts of different issues. We are not able to meet the full need of low-income folks around the state facing civil legal issues. And so Northwest Justice Project also operates what's called CLEAR, and that's an acronym that stands for Coordinated Legal Education, Assistance, and Referrals. So CLEAR is a place where it's the very general screening line for all of Northwest Justice Project services. So folks can call in, and there's attorneys that are able to respond to callers. When we can't provide full representation, those callers can receive advice and counsel, sometimes some limited assistance or referrals to other local agencies who might be able to help with their issues. And one of the reasons why I wanted to bring that up is because it's not listed here, and it kind of it comes into play a little bit later in my presentation. Okay. So I'm here representing the Eviction Prevention Unit, which is a new unit at Northwest Justice Project, new as of about last August. It was formed in response to the state legislature passing 5160, which Ted and Noah both spoke about, which gives tenants facing evictions a right to counsel in these eviction cases. So the Northwest Justice Project is the only statewide right to counsel trial court provider right now. I say we're statewide. There's a handful of counties that we don't have a presence in. But this map shows where we are. We're basically statewide. We work collaboratively with legal aid programs in all of these different organizations where there are multiple providers so that we can make sure everyone gets served. And Northwest Justice Project's Port Angeles office has one eviction prevention unit attorney who serves both Clallam and Jefferson counties for right to counsel cases. This is just the text of the statute that that requires the court to appoint counsel for folks facing evictions. I am not going to read this to you because I trust that everybody can read it, but it talks about, it outlines that the court must appoint an attorney for an indigent tenant. It mentions that the Office of Civil Legal Aid, which is a state agency, is responsible for administering and implementing this program. And then it defines what indigency is and how that's determined. And I just wanted to make sure that folks had the text, knew where to find it, but I will talk about these things in a little bit more detail based on the next slide. So what does it mean to have a right to counsel in eviction cases? Low-income tenants and mobile homeowners may qualify for free legal representation. One thing that I think that we've seen as this program is rolled out over the past few months is some misunderstandings in who actually qualifies. So one really important thing that that we have been seeing happen is a misunderstanding that this was only created in reaction to the pandemic and only to address non-payment of rent cases. So that's not correct. A low-income tenant who financially qualifies has a right to an attorney in any sort of eviction case, not just non-payment cases. I am not going to be able to pay attention to the chat as I go, but I will do my best to go back and address questions as they come in. So to figure out who qualifies for a right to counsel attorney in these situations, one thing that is a little bit tricky about the right to counsel statute is that it's pretty clear, and I will go back to this, that a tenant gets an attorney when the court appoints an attorney to the tenant. And so what that means is that a tenant doesn't actually qualify for appointed counsel until the court has some sort of jurisdiction. That means that the case in court has to be commenced either by filing an eviction lawsuit or by serving the client with an eviction summons. I know that in some counties, and I'm not sure how prevalent it is out here in Clallam and Jefferson, but it's not unheard of that eviction cases get started by serving an unfiled lawsuit on a tenant. And so that will trigger right to counsel for someone, even if the case isn't filed with the court. What this means in practice is that a tenant who receives a 14-day notice, a 10-day notice, 3-day notice, 90-day notice, any kind of notice that can be given, means that they don't qualify at that notice point. They need to have a summons in order to be connected to a right to counsel attorney. Let's see. Okay. And then what else do they need for qualifications? It's outlined in the statute that I just showed you, but folks do have to be indigent, in other words, low income. And under the right to counsel statute, they define that as at or below 200% of the federal poverty level based on income after taxes. That's something that's very different than most public assistance qualification programs. Most programs base it off of gross income or before taxes. And so it creates a little bit more complex screening structure for right to counsel. There are also the law that I just showed you also shows a handful of different public assistance programs. If somebody receives any of those benefits, then they automatically qualify for a right to counsel attorney, because in order to receive those benefits, they've already had their income checked and tested to qualify for that. Because of some of these complex financial eligibility rules, the main point for eligibility to be determined is through the statewide eviction defense screening line. Representation in Clallam and Jefferson County is primarily going to be provided by by Northwest Justice Project's Eviction Prevention Unit attorney, who's based out of Port Angeles. Unfortunately, we had somebody who was up in the area for several months, Hannah Harrison. I think many of you may know her. She's recently moved on to a new position, so we're working on getting somebody in right now and have staff filling in to help cover those cases as we can in the meantime. There are going to be some situations where Northwest Justice Project isn't able to take a case. That is usually going to be that doesn't have to do with the merits of the case itself. It will often have to do with a conflict of interest, or potentially we have some federal funding restrictions that apply to all Northwest Justice Project programs. And so if there are situations where it's not a program that Northwest Justice Project can normally serve, we actually have a contract attorney team that we can send those cases to, who can help provide representation for when folks qualify for appointed counsel. Okay, so how does someone get a right to counsel attorney? The best way for someone to be screened, like I mentioned, is to call the eviction defense screening line. That phone number is here. These are the hours, so it's open Monday through Friday, 9 to 1 p.m. and then 9 a.m. to 1 p.m. and then from 2 to 4 p.m. This phone number is provided on, by statute, it's provided on all the 14-day notices. And on all of the eviction summonses. So that's what's required by statute, to have that information on there. Tenants who believe they are being evicted should call the eviction defense screening line. We recognize that legal paperwork can be really confusing. People don't necessarily understand what they're getting all the time. If you ask someone if they received a summons, that might not mean something to them, because that's complicated legalese that just your everyday person isn't necessarily going to know. So if people have concerns that they're being evicted, we really encourage them to call the screening line. The screeners will talk to them, try to determine what kind of paperwork they've received, and then go over financial eligibility. And then if they end up not being eligible to be connected to attorney for full representation at that time, the screening line will route those calls as appropriate. So say they haven't actually received a summons yet. The screening line can route the case to CLEAR or to a local provider like Ted's agency to receive advice and counsel before they qualify for appointed counsel. If they have received a summons, then they'll get referred over to the eviction prevention unit. Is it actually not an eviction at all? It's a different kind of legal issue. The screeners will figure out how to route those calls. We want to make sure that it's an open door and that people have as many ways to get connected as they can. We don't expect folks to be able to identify legal issues on their own necessarily. So we want to be able to help with that. So my tip here is that if a client has an eviction notice or a summons, or even if they just think that they might be getting evicted, direct them to the screening line and we'll hopefully get that sorted out for them. I want to address one question in the chat really quickly. Is eviction counseling available to undocumented? Yes, right to counsel applies to everyone in the state. I will say that Northwest Justice Project, because of the federal funding restrictions that I mentioned earlier, we have limitations on our ability to serve folks who are in the country without documents. And so that is one of the reasons why we have the contract attorney program, who can help take those cases. If my unit specifically is unable to provide that representation, but anyone should call, because it's a state law and everyone is entitled to it. One thing for folks who are familiar with CLEAR, they might know that CLEAR can be really hard to get through to. So I really want to emphasize that the eviction defense screening line is not the same phone number as CLEAR. This can be really confusing because both phone numbers are on the 14-day notices, but CLEAR, because they are actively providing advice and counsel to folks on the phone, they have to limit intake, and they usually have to shut down on a daily basis and can't take more calls. When folks call the screening line doesn't shut down. You saw that they close for a lunch in the middle of the day, but callers are able to leave a message if they can't get through. Screeners do their best. They're pretty good at making same-day callbacks when folks call in early enough during business hours, and then the screeners process the calls very quickly and route them to the appropriate right to counsel provider. if someone calls the screening line, they usually get screened that same day. And if they get screened that same day, they get routed to the eviction prevention unit. And it usually takes 1 or 2 business days for an EPU attorney to call that client back and get the ball rolling on things. Sometimes tenants aren't able to call before the hearing, or they don't understand the paperwork, they don't understand what's going on. They know they have to appear in court, but they're not sure how to get connected. So it's not uncommon that tenants will show up at court without an attorney with them. If that's the case, there are the standing orders for both Clallam and Jefferson counties outline the procedures that the courts go through when a tenant shows up to court without representation. So under the statute, as a reminder, it says the court must appoint an attorney for an indigent tenant in an unlawful detainer proceeding. And so the standing orders for Clallam and Jefferson both say that the court is responsible for advising the tenant of their right to appointed counsel and asking if they want to assert that right, referring the tenant to the appropriate provider. In the situation, it's the best place to route those folks is to the eviction defense screening line, and then to continue the initial hearing to allow that tenant to have time to connect with their attorney, give the attorney time to actually look at their case and understand what's going on. The Clallam County order specifically says that the hearing would be continued for not less than 1 week. Even though there's really only one primary provider in Clallam and Jefferson County, the process is not designed to have the court appoint attorneys from the bench. And one of the reasons is that complex financial eligibility screening that we talked about. And we also want to make sure that we protect the privacy of tenants to the extent that we can. If they're claiming that they believe that they're indigent and they qualify for an attorney, they're already discussing that they're low income, but they don't need to be expressing their full income situation on the record. And even if they were doing that, it might be more complex than the bench is able to figure out as far as eligibility goes. So it's really important that those calls get routed to the eviction defense screening line. Another reason that the appointing from the bench is not generally available is because it might not be an appropriate case for Northwest Justice Project to take based on some of the restrictions that we talked about, or based on conflicts that might existing conflicts if we've advised adverse to that person before. And so that's why it's really important to make sure to direct people towards the eviction defense screening line. And I know that NJP has provided postcards in the past. I can make sure that more of those are obtained if they're needed for the courthouses. And the postcards have the eviction defense screening line on them. After that, these attorneys are on the case. They provide full representation to clients who are facing eviction, and subject to all of the rules of professional conduct, all of the court rules that all regular attorneys are required to follow, but also with the responsibility to zealously advocate for their clients. That was really quick, and I unfortunately have a conflicting 1 o'clock appointment. I don't know if there's any quick questions that folks might want to ask me, or if there are follow-ups, I'm sure I could respond via email and coordinate that with Shauna.
Okay, I'm not sure if I'm supposed to jump in here or not, but just in case I am, thank you very much, Michelle, for that presentation. And I'm sorry you'll have to be leaving us, but if anybody needs contact information for her to have some questions answered, please feel free to let us know and we'll provide that information to you. So let's move on to our next presenter, and that's going to be Renee Riopelle. Renee is from the Peninsula Dispute Resolution Center and serves as the executive director. So take it away, Renee.
Thank you, James. Okay, so let me get my PowerPoint ready here. So like James had said, my name is Renee Riopelle. I am from the Peninsula Dispute Resolution Center, and I have a PowerPoint presentation for you today. All right, I can't see anybody, so can someone let me know if you can see the screen?
You have it on presenter view. So you want to select the one that just has the full slide of your. So when you share screen, it'll give you a couple options. Choose the one where your full screen is in view of your slide. Otherwise, we're just going to see both your screen, you know, like your next screen going forward.
How is that?
Better. That's perfect.
Okay. All right, so Peninsula Dispute Resolution Center, pdrc.org. I'm going to just share a short presentation with you, including a video short of the eviction resolution pilot program. So the next slide, it looks like Ted and Noah went over those already, but these are the teeth behind the ERPP program that I run for Clallam and Jefferson County, and that is the Senate Bill 5160, signed into law April 22nd, 2021, the revised Code of Washington 5918-660, and then most important to my programs are the Superior Court standing orders, and they govern the partner agencies' processes, timelines, obligations, and certifications. So ERPP goals. First and foremost, it is to stabilize housing, reduce the court caseload, offer early resolution to disputes through conciliation and mediation services, hook people up with rental assistance, and then support low-income tenants and landlords with legal aid, meet and confer mediation, and then the court, the right to counsel. Okay, so where I'm at in the process is the eviction resolution program has 3 pillars. One is rental assistance, the other one is legal help, and then mediation or dispute resolution services. So here is a 2-minute video of the ERPP program.
Are you a renter worried about rent you owe, or getting evicted, or becoming homeless? Are you a landlord with tenants who have fallen behind on their rent? Dispute Resolution Center mediators across the state are available to help tenants and landlords talk about solving these problems without going to court. Services are free, confidential, and available regardless of immigration status. The Washington State Courts created the Eviction Resolution Program to connect landlords and renters to rental assistance, to legal help, and to each other through mediation. Mediators can help you work to solve the problem. The goal is to stabilize rental housing for everyone. As we all get through these tough times, we can work together to build a safer, stronger community. Contact your local dispute resolution center today to learn more about these free services.
Okay, so next I want to go over the ERPP process. And so the ERPP process allows landlords, they don't necessarily need to hook up with an attorney. Most of my cases do not have attorneys. They simply file the notices to the tenant, provide me copies of those, and then that allows me 14 days to provide services and hopefully get the landlord and the tenant communicating to come up with a settlement agreement. So the first thing, it starts with the ERPP begins with the ERPP notice and pay or vacate notice. And this is served by the landlord to the tenant and to the dispute resolution center, hopefully at the same time. The tenant chooses whether to move forward, but must respond timely because I do only have those 14 days. The tenant may contact us directly from the local resource provided on the ERPP notice, and I'll show you those forms in just a bit. Or the tenant may be contacted by the DRC and accept services. And for my program, that is most of the time that I'm trying to contact the tenant. So if the tenant accepts the services, they have eviction resolution specialists, that's what they're called, and they work to help the landlord and the tenant resolve their dispute informally. They help the landlord and tenant communicate through conflict coaching. They also help the landlord and tenant access resources, and we do that by sending letters, texts, phone calls, regular mail to let them know about rental assistance and legal advice. We also conciliate the dispute between the landlord and the tenant, helping them prepare and exchange offers and response to offers. And then we facilitate any formal negotiation that needs to happen between the landlord and the tenant. This may include counsel, and then parties may reach an agreement at any time. And it's been my experience that as I go back and forth conciliating through the phone, that most agreements happen at the conciliation phase. And it's very helpful, landlords, if you provide me with a ledger or your landlord reasonable repayment offer. The more information that I have, the more information I'm able to, when I go back and forth between the parties, have a more productive conversation. So the ERPP finishes with a certificate of participation, and this varies for each county's standing order. Clallam and Jefferson is just slightly different. And then under the statute, landlords must have the DRC certificate before an eviction case may be heard by the court. So these are the ERPP forms that I use often. And you can get these forms on the Attorney General's website. They come in 15 different languages. And our form for Clallam and Jefferson is on our website, which is www.pdrc.org. So the first form that I want to talk about is just the ERPP notice. So there's a statutory requirement. An ERPP engagement begins when the landlord serves the tenant both the ERPP notice and the pay or vacate notice. It must contain complete contact information for the tenant and the landlord, plus the attorney, if any, including property address, phone number, and email address. And so the biggest issue I have right now is that I'll have the tenant's name and address, but I do not have a phone number or a working phone number with no email address. So if I have 14 days, it becomes very difficult when I've got to start this through the regular mail. Then all the information you can about the landlord and the attorney, if they're being represented by an attorney. Both notices are sent to the local DRC serving the county in which the property is located. So sometimes I'll get King County's ERPP notices and I've got to say, no, you've got to go to your county. And this is also written in 15 languages. And the second page of the ERPP notice, it lists the local resources for rental assistance, dispute resolution center, and lawyers. And the tenant must respond to this ERPP notice within the 14 days. And so it's very helpful if all of that is complete and accurate. If it's not, I do send it back because that is something that the tenant is receiving. And if I'm not going to get a hold of them, it's good that at least that I know that they have this second page of the ERPP notice. And then please, when you're providing me with the notice, to also give me a copy of the second page. So this must be accompanied by the 14-day notice to pay or vacate. I'm sure all of you know what that looks like. And this is the certificate. The certificate is issued, certificate of participation is issued, and this provides the landlord and the tenant's information, the attorney's name, and the method of contact. This is the third or fourth round of certificates that we've looked at and changed. And this most recent one, because we have to have a minimum of 3 times points of contact for the tenant, they want to know exactly, if you're going to go halfway down the page, it says the date and the method. And so we need to put that on there, the date and the method, whether phone, regular mail, email, that we tried to contact the tenant. And just pertinent information. Did conciliation occur? Meet and confer, mediation, and if there was a resolution. The second page allows the DRC to provide additional information regarding rental assistance and ERPP processes, the notice and intake conciliation, meet and confer, mediation, and any other pertinent information that would have the judge see if this is right for adjudication. And one thing I like to think about is that conflict is really difficult for a lot of people. And what happens is that negative connotation has people avoiding conflict. But if you think about conflict as just a natural part of life and taking a deep breath in that, your mind can go to, hey, what is the resolution going to be? And get excited about having some peace. So I think with the dispute resolution, communication benefits that you develop the ability to clearly express your needs and requests. And this is all a part of the conflict coaching that goes before most mediations happen. So there's a lot of pre-work done. It helps avoid the escalation of conflict. You can model calm response, gain insight of self and other perspectives. And that's so huge right now with so many things going on right now. It's not just the conflict or the resolution, it's how the world is affecting those two things. So it does open up other people's perspectives and what might be happening. The action step plus the accountability creates visions of resolution. Please focus on that. Conflict is natural. What can happen? What can I get excited about? What needs do I have that can be met? And also the other side. And then the personal result is clarity, self-care, personal control, and hope. So thank you. Here is my contact information. And at the end of every email, I have this saying, and it's by Theodore Steinway. In one of our concert grand pianos, 243 taut strings exert a pull of 40,000 pounds on an iron frame. It is proof that out of great tension may come great harmony. So thank you. Let me stop sharing so I can see if there's any questions.
Renee, there was one question asked in the chat that I've attempted to answer. The question was, other than for evictions for non-payment of rent, does the ERPP apply?
No, ERPP, there has to be past rent owing. We have several mediation programs. And so when that happens, it just goes to another of our mediation programs where almost everything is mediatable.
Okay. That was the only question I've seen. If anybody else has a question for Renee, feel free to drop it into the chat. Or what do you represent clients subject to common law ejectment? I think that may be a different issue.
I'm familiar with common law, but ejectment, could you explain that word?
Yeah, that is the question from Chuck. And perhaps we can address that a bit further in the chat. So we will ask for an answer to that question there and give Renee thanks for presenting today. If any more questions are out there, feel free to put them into the chat or into the Q&A section. We'll now move on to Cherish Cronmiller. Cherish is the executive director of the Olympic Community Action Program, as most of us know it as OlyCAP. And Cherish, take it away.
Good afternoon, everyone. Hopefully some of you have gotten lunch or you're noshing on something now. I'm going to be short and sweet here to let you all know that rental assistance is still available. OlyCAP is the primary or lead housing agency in Jefferson County. So we're the entity in Jefferson County providing the rental assistance, and Serenity House is the lead agency in Clallam County. So Serenity House is the entity that has rental assistance dollars available there. I'll just share quickly in case I see a lot of familiar names on the chat. So I appreciate my board members and staff and other folks that are joining us today. If you've never been to the OlyCAP website, I encourage you to do so. If you're looking for housing assistance, you'd go to our website and you'd click on the button that says Ask for Housing Assistance. And we have a new appointment scheduling system. And so you would click on New Appointment and start to, fill out information at that time. I also want to acknowledge the Jefferson County Anti-Racist Fund. They are a partner of ours. They're a BIPOC organization who's helping us reach the BIPOC community and have helped us get over $70,000 out the door to the BIPOC community in Jefferson County. So if you're a person of color, someone who is undocumented, feel a part of a marginalized group, I encourage you to reach out to the Chimicum Center, the Anti-Racist Fund, and you can get housing assistance, a referral through them to us as well. And want to let you know that the agency, let me see, I don't know if you can see that screen when I switch from a spreadsheet to a thing. It doesn't always like that. So, we started giving rental assistance out in March 2020, and we have different types. Prevention is where we attempt to prevent the eviction from happening, right? And we've had various dollars available for that, whether it be through the Peninsula Daily News Home Fund, through some of the federal programs that came through Commerce to us. And so we're grateful for all the sources of support. But, since March 1st, roughly of 2020, up until last week, we've issued, as you see there, over $3.4 million out into our communities. And a majority of that is in Jefferson County, but we do have some dollars available for Clallam, just sometimes, special cases, just depends. If somebody's been affected by COVID, we ask them to reach out and ask for assistance, especially if you had a COVID effect. We still also have some dollars for mortgage assistance that have helped a number of folks as well. So definitely encourage, if you haven't done so, and landlords are able to apply for assistance through our program. Okay, so if your renter is not following up on their rental assistance, then I'm going to encourage you landlords to fill out that information because qualifications, really just has to have some nexus to COVID. That's not highly documented. We've all been affected by COVID one way or another, so it's not a lot of documentation. I recommend to folks, right, my perspective, though I'm attorney, I don't litigate, right? I deal in the realm of reality of our working class and low income individuals in our community. So, if you're in a place, do not leave that place. And I tell you not to leave until, literally the sheriff has issued that you are going to be set out. And also communication is the most important thing, right? Try to work with your landlord, even if it's not a non-payment of rent issue. Utilizing the mediation center, is a wonderful tool to be able to work out and solve any type of issues. Don't be afraid to potentially ask your landlord for compensation if there's certain things that they are wanting that's beyond the scope of your lease. We have had some people and some landlords pay people off essentially to buy them out of their lease. I don't recommend that because you're not going to find another place up here on the peninsula, but you want to be sure that you're hedging your bets appropriately there. So, a lot of our folks that we serve obviously can't afford an attorney, so they're going to be utilizing the mediation center or if paperwork already has been filed, potentially going to NJP and utilizing the clear line there. So, what we're seeing a lot of is, landlords sharing rooms with tenants, right? And maybe they don't have a formal lease agreement. We also have people who are living in situations that really maybe are not meant for habitability, right? They're living in a shed, they're living in a camper that's not hooked up to utilities. They don't have access to heat or hot water or any water. So in these situations, my best recommendation for folks is to make sure that you try to put something in writing, all right? And don't try and be fancy about it. Really just write out what your agreement is, right? If you've got somebody who's going to be sharing that room, you're expecting that they're going to be there for 6 months, they're going to pay a certain amount of money, write that out and have both of you sign it, right? So just put in plain language what it is you're trying to accomplish here, right? I also want to say that for those of you landlords that are renting places that maybe are not meant for human habitability, you're running electric out to a shed or things like that situations, I still want you to apply for assistance, right? And that includes energy assistance, right? We're not out at the agency to try to tell you or call code enforcement. It's tough times out there, and we're going to try and do our best to get you housed or in a better situation. But meanwhile, if you're a landlord, you're trying to pay a high energy bill, right? Because you have electric cords running. First, be careful because we're worried about fire. But we want to provide that assistance. Our goal at the agency is to keep money in our community and keep that assistance flowing. So that $3.4 million that went out to landlords in our community. We don't have a lot of, large landlords in our community. We don't have these high rises that are owned by mega property owners. So that's important. And, we just recommend that you try and give people the benefit of the doubt. And we appreciate people reaching out to our services or those of Serenity House, trying to do what we can to make sure that we stabilize people in our community. I want to leave at least 7 minutes for questions, so I'm going to cut off there.
Thank you, Cherish, for your presentation. And if anybody has any questions for her, please drop them into the chat or into the Q&A section. But we would like to give at least a few minutes to our Honorable Judge Simon Barnhart, who's going to kind of wrap things up with a bit of a judicial perspective on things. So Judge Barnhart, please proceed.
Okay, James, thank you. And I'll be brief. We all have things we have to do this afternoon. I think we have a few people involved in this proceeding that I'll be seeing on the 1:30 calendar. So I don't want to take their time beyond what I've been allowed here. I want to thank our panelists for thoroughly covering the legal developments, and Mr. Harrison and Mr. Howard did a very good job of giving you all some perspective on the law. And I really don't have anything to add to that. I want to confirm and elaborate a little bit on the court's administrative orders that were entered in response to the call from the legislature to participate in the eviction resolution pilot program, and also to develop a system for implementing the right to counsel legislation locally. Northwest Justice and Pro Bono, through their Housing Justice Project, responded very quickly to ensure that we would be able to provide counsel, and therefore to be able to resume with unlawful detainer proceedings. We were held in abeyance until those programs were underway, and the Office of Civil Legal Aid approved the right to counsel attorneys that we have for our area. And everybody rallied to the call and made it possible for us to be able to open up the floodgate a little bit. We haven't seen the inundation of unlawful detainer cases that we were anticipating. I think that may be in part the result of what we're hearing from Renee, that a lot of unrepresented people are taking advantage of services of PDRC for those non-payment of rent cases. And I think that was really primarily going to be driving unlawful detainer action. So the court's docket hasn't been as congested as we anticipated, which I think is an indication of the success of these programs, and a tribute to the hard work of the people behind the scenes. As you think about the ERPP, keep in mind that it is just a pilot program. The authorizing legislation only gets us through July of 2023, which is still a ways down the road. But for landlords who have some interest in whether they're going to be bound by this type of pre-litigation resolution program, the legislature is going to speak on that. Courts have nothing to do with whether we will continue to require this type of program until we hear something more from the legislature on whether the pilot program is deemed to be a success or some changes will need to be made. Again, it is a proceeding that's mandated only in those non-payment of rent cases. So we do have a threshold issue when we see pleadings for evictions based on non-payment of rent. One of the first things that we look for at the very outset is whether the ERPP certificate has been filed. So if you have that certificate, make sure that you include it with your court filing so the court knows that you have participated in that program. We'll be wanting to ensure that that part of the requirements has been fulfilled. Typically we see that that's happening on ex parte at the petition or motion for a show cause order, but that's not always the case. We don't always have show cause hearings. Sometimes landlords wait and see if they'll get a default, at which time then the court would be looking to see whether the ERPP certificate has been provided. With respect to right to counsel, the court undertook to develop a bit of a process here to ensure that when a person is entitled to counsel, they get that. And so we have a couple of documents. I don't know whether Sean is able to put those up, but we have an order that we use to continue the show cause hearing. We have two forms of that order. One is when we expect that Northwest Justice will be the assigned counsel, and the other is when the Housing Justice Project may have to get involved because of reasons we heard from our NJP attorney when there might be a conflict or lack of availability of a Northwest Justice attorney. Here you have our administrative order on the ERPP. Maybe somewhere further down we have the court's form of order continuing the show cause hearing. So what happens at a show cause hearing generally is the court will first inquire of the tenant whether they may be eligible for right to counsel services. We do not determine eligibility, but we do have a responsibility to determine whether the possibility of eligibility for right to counsel representation is there. It happens sometimes we have tenants who aren't indigent. So we have to separate out those types of cases that can proceed to show cause and those that may require some time for a determination of eligibility. So we have a financial eligibility questionnaire that we run through with the tenant, which the basic questions establishing eligibility based upon the statute. And then if we do determine that the tenant is potentially eligible for right to counsel services, we enter an order continuing the show cause hearing. There's our financial eligibility checklist that we just go through from the bench. That's not something that I guess filed for the record, but it helps guide us in the eligibility threshold questions that we need to ask. And once we make a determination of the potential for eligibility, we'll enter an order continuing the show cause hearing. The standing order contemplates at least a week. Typically, we're allowing 2 weeks time. And you'll see in the order that we do direct the tenant to within 3 business days of entry of the order, contact either the eviction defense screening line, and we provide that phone number, or to apply online at the NJP website. We also send a copy of that order to NJP or to Pro Bono if it's a Housing Justice Project assignment, so that they have notice that we have a proceeding that may require right to counsel representation. And we also have a document that we file under seal where we request the contact information for the tenant. This is something that we also provide to the legal services provider, so they are able to reach out to the tenant promptly and make arrangements on their end for a conference to discuss the case. So we put the burden on the tenant on the one hand, but we also provide information to the legal services provider to ensure that they're able to follow up on their end as well, in the expectation that we'll be able to make that contact between the attorney and the tenant sooner rather than later and not have further continuances of the show cause hearing. Mr. Harrison touched on a couple of things that I want to follow up on. I think that I'm satisfied with the way that he's identified the kinds of issues that come before the court. Some of the things that we see are insufficient notices and insufficient summons forms. So landlords and attorneys representing landlords, please be mindful of the statutory requirements for the contents of the notices and the contents of the summonses. And for those for-cause evictions, the statute does contemplate a level of detail when describing the basis for the alleged default under the lease. And so we're looking for accuracy and completeness in those notices. And that's a bit of a threshold issue. Proof of service is another problem that we see. It's important to have a certificate or affidavit of service in the file prior to the hearing so the court knows how the matter might be proceeding. If we don't have proof of service, our starting point is we don't have confirmation of jurisdiction, and that can hang things up for people. So making sure that you've gotten your proof of service in the file is critical. Keep in mind too that the show cause hearing for the order to issue the writ is a summary proceeding. It's a general matter. And we don't really get too deeply into fact questions at that hearing, depending on the nature of the proceeding and the basis for the eviction. But if we do have significant fact issues that give rise to some uncertainty as to whether it's appropriate to issue the writ, we direct the parties to set the matter over for trial. So these are processes that take time very often and can be fact intensive. With the new legislation that we have, it becomes a little bit more complicated. So it's not a quick proceeding in the way that maybe it was in the past, unless it's a non-payment of rent case where we don't generally see a lot of fact issues. I want to take just a minute to thank our members of our bar who do take these types of cases. I see a lot of frustration out there among the small handful of attorneys who do this kind of work on both the landlord side and the tenant side. It's some of the most important work that we see in our courtrooms because of the interests that are at stake on both sides. The cases can be difficult, they're emotional, they're sometimes tragic, they're compelling interests on both sides that deserve to be represented and have full voice in the courtroom. I think the new legislation has done a good job of curtailing the amount of defaults that we see. I don't know that it's necessarily changed the outcomes, but giving people their day in court and their opportunity to be heard is a big part of what we do. And for you attorneys out there who do the work, we thank you. And for those who are avoiding it, I would encourage you to look into it. It's an opportunity, and it's also an important part of being a representative of the interest in your community, because we do have a lot of landlords whose voices need to be heard, and they're having difficulty finding attorneys, and we have a lot of tenants whose voices need to be heard as well. And NJP and the HJP are doing a terrific job, but there are people out there who don't qualify for those services, and they're trying to handle these things on their own, and it can be very difficult. I'm out of time, and I got to get to court, so I'm going to have to cut it short. I'm sorry that I'm not able to go any further than that, but I do thank you for the opportunity, and thank you to Pro Bono for putting this program together. It was a very good one today.
Thank you, Judge Barnhart, and hope to see you soon.
Okay.
Everyone, that is the completion of our presentation today on navigating evictions in 2022. As you can see, there is an awful lot of navigating that needs to be done. And so I'd like to take a moment to thank our presenters. We had a number of presenters from our community, and I think the information presented is hopefully very helpful to all of the members of the public who may have been present, as well as the attorneys who have been present to listen to those presentations. Would like to remind anybody who has additional questions that they can reach out to the Clallam-Jefferson County Pro Bono lawyers for assistance and direction. The website is cjcpbl.org, and you can find contact information there. We're also happy to accept donations there as well. So if anybody else has any questions or concerns, please direct them that way. And with that, I think we will say goodbye and good afternoon. Thank you.